With the week is Concordia, and I want to thank you for allowing this topical issue this evening. I'm disappointed the Minister O'Brien is not here, the Minister of Housing, but I would like to wish you, Concordia, and all the people here and staff and everybody else, everybody happy, holy, and a safe Easter. It's very important that we reflect on times of Holy Week and indeed Easter Sunday for the risen Lord is very important. And thank you. I am raising the urgent need for an emergency ministerial order, a statutory instrument, pausing planning enforcement proceedings on log cabins, where to continue with such proceedings will cause further homelessness. This can be done. The Minister for Housing signed a similar statutory instrument exempting certain developments from planning permission for housing Ukrainian refugees. We need a similar measure for our homeless Irish citizens. Minister O'Brien has signed European Urban Planning and Development Displaced Persons from Ukraine Temporary Protection Regulation 2022, Statutory SI 306 of 2022. The regulation, which came into effect on the 23rd of June 2022, provided certain classes of temporary developments, including residential accommodation, undertaken by or on behalf of the state authority to provide protection to displaced persons from Ukraine will be exempt from Housing and Planning and Development Acts, other than environmental considerations. The specified development classes will not require planning permissions for the period that the regulations are in place, and will not be subject to the various restrictions that would normally apply to classes of exempted development. Welcome to publication, Minister O'Brien back at that time stated that his department had committed to working with the Department of Children, Equality, Disability, Integration and Youth to provide urgently needed shelter and support to Ukrainian refugees. These guidelines will fast-track the development of temporary accommodation, including modular units, by or on behalf of the state authorities, by removing the requirement to seek planning permission where appropriate. And now, I have Sean Mian's case in Woodenstown Care, proud 66-year-old Irishman, a Republican family and a Republican man and a good, decent man who fell into difficulties in a wedding, and I have permission to mention his name, in marriage, had a separation, were divorced legally, and he bought a plot of land and put a mobile home into it and carefully crafted a lovely wood exterior and also insulated. It's very warm comfort for him and his cat and his dog. And lo and behold, he's before the courts and threatened. Before the courts, yeah, well, it is. But anyway, a statutory instrument can be signed, our Minister, in his case. And I have at least 12 others in South Tipperary that some have removed their lovely log cabins, forced to remove them by the local planning authority. This is ridiculous in a housing crisis where people want to house themselves, are able to house themselves sensitively now, aesthetically pleasing and not causing any blockage. So I want this statutory amendment signed immediately. We have no planning, we haven't had a review of the planning guidelines for 20 years. We're crying out for them. We've been promised them, the last government, Fianna Fáil, Fine Gael, promised them during the election. We're told now that the tail is wagging the dog. The green tail is swishing all over the place and stopping the government from introducing these planning guidelines. 20 years on, we don't have them changed. And included in these planning new guidelines could be this statutory instrument. This statutory instrument could be signed next week, could be signed the week after when we come back here. It needs to be signed in the middle of this housing crisis to allow people like Mr. Mian and others to be left to live in their own comfortable abode that they provided themselves at no cost to the state.
Good. Minister, please.
Thanks, Chair, and thanks, Deputy McGrath, for raising the topical issue relating to planning enforcement proceedings in respect of unauthorised development of log cabins. Firstly, I would point out that under Section 30 of the Planning and Development Act of 2000, and as amended, the Minister with responsibility for planning is specifically precluded from exercising any power or control in relation to any particular case with which a planning authority or the board is or may be concerned. This includes matters relating to enforcement under Part 8 of the Act by any planning authority. With regard to the specific case or motion submitted by Deputy McGrath, the position is that all development proposals require planning permission unless they are specifically exempt under the Act or the Supplementary Planning and Development Regulations of 2001 as amended. In addition, national planning policy, guidelines and legislations do not dictate the types of materials that must be used for housing, and accordingly there is no prohibition on the use of timber in the construction of a house from a planning perspective, subject to the overall proposal for planning permission being in accordance with national, regional and local planning policy. In addition, there are no restrictions under the Planning Code for any person to apply for planning permission in respect of modular or log cabin type accommodation. Furthermore, a range of factors have been taken into account in the assessment of proposals of all forms of housing, including modular or log cabins, including requirements for access, car parking, amenity space, as well as separate services such as water, drainage and electricity. It must also be noted that such proposals may also have implications for neighbouring properties and the visual amenity and the character of the area, which must also be taken into consideration in the determination of a planning application. An application for planning permission also provides for an opportunity for members of the public to make submissions or observations in respect of the proposed development. The Planning Authority is required to have regard to any submissions or observations received on a planning application during the public participation process in accordance with Section 34 of the Act. It should be noted that Part 8 of the Act does, and this is the important part, Part 8 of the Act does not provide any regulation making powers to the Minister with responsibility for planning in relation to enforcement. This therefore precludes the making of regulations that would allow for the pausing of enforcement proceedings in individual cases. Therefore, the issue raised is a matter for the relevant planning authority to investigate as appropriate on a case-by-case basis in accordance with Section 153 of the Act. The decision to issue an enforcement notice in respect of the unauthorised development and the contents of any such notice is a matter for the relevant planning authority under Section 154 of the Act.
Thank you, Minister. Deputy McGrath.
I'm very, very disappointed with the reply because, Minister, you stated something there that timber wasn't a problem. One of the two reasons that a person I'm talking about was refused planning by the County Council on 2 occasions. The second reason, and the case was, the reason that it didn't get planning was the nature aesthetic of the structure. That means it's timber. Negotiations are going on now. He's been told if he plasters it, or renders it, he might get planning. So this is baloney. This is, we're coming up to Easter Sunday down at Costa, where we're going to celebrate our freedom fighters who gave their lives in 1916. And a week later we're celebrating Liam Lynch, who is only 15 miles where he lost his life away from where the case I'm talking about. And this is what you tell Irish people. We can introduce regulations for our people to come in from the war of our own country. And I have no problem with that. And we can't do it for our own citizens. What is wrong with our government? What is wrong with our people? So you're wrong, Minister. The guidelines, and Minister O'Brien did inform me here, and I raised this earlier, that he had written to the Tipperary County Council, asked them to relax the guidelines, but in fact he hadn't. So again, Concola, I was misled in it all by that. No, I was, and he hadn't done it at all. So what are we talking about, people that we can't allow? I told you I have a number of people who have removed these beautiful log cabins. I have a man from Galway on to me at the moment, your constituency, Minister. They're all over the country. I would estimate up to 10,000 of them, and those 10,000 people would be added, and we'd have instead of 15,000 homeless, we'd have 25,000 homeless. What are we thinking in this government, in this times, we're approaching Easter week, as I said, and the Gallen men of 1916 and 1921 and 2 and 23. My goodness, to do this to an Irishman and Irish women, in the name of dead generations, and doing this. And you know yourself, you're well aware, in a rural constituency, I said the man from Galway, but also the planning here. He had fell on tough times, separation, and the standard that Tipperary County Council want to apply for local need is ridiculous. I believe the standard is too high, and the Minister needs to look at that, and so do officials, because...
If I could interpret for a second.
Yes.
What you and what the Minister are at odds about here is that we're being told that legally the Minister has no authority to enact legislation to overrule an enforcement order. The local authority, on the other hand, has the wherewithal to withdraw its enforcement action.
Of course.
Okay.
But I'm asking for a statute. Sorry.
No, he doesn't have. He's saying to you, he doesn't have. Wait now. He doesn't have the statutory power to supersede an enforcement order.
I accept that.
He would have the statutory power to introduce a new provision providing that local authorities would deal with other cases not the subject of enforcement.
Councillor,
my reading of what the Minister is saying to us.
Councillor, yes, that's what I put down, that's what I submitted. A statutory instrument
Well, can we hear the Minister?
to allow for, there's hundreds of these, and thousands, I said, all over the country, in the city as well, so that's what I'm looking for, to make sense. It's a pillar, one pillar, to solve our housing crisis, and a very good one.
Thank you. Minister, please.
Yeah, and
Sorry, I'm not trying to come...
Absolutely, and look, I understand fully the points the Deputy is making. I come across it in my own constituency quite regularly, and you've pointed out one instance in my constituency that you're aware of. Look, I'll make the Minister absolutely aware of the points that you've raised here today. He can't halt an enforcement under the Act, under the law of the land. He cannot step in and write a statutory instrument or create a regulation to halt an enforcement. He just does not have that authority or power as Minister under the Act, under the Planning Act. And I think you'll appreciate that. But there are ways, obviously, that the local authority in question can deal with it. Obviously, enforcement is one way, and you're trying to find a way out of that. There's obviously the individual can apply for retention. Depending on the outcome of that application, he can apply to An Bord Pleanála for An Bord Pleanála to look at it, or he could vary the proposal and make another application. There's lots of avenues open there, but the Minister doesn't have an avenue open to him to create a statutory instrument to allow a regulation to intervene in enforcement proceedings that are before the court.
Okay.